May it please the court, Brian Lee on behalf of R.J. Reynolds Tobacco Company. I will reserve 5 minutes for rebuttal.
Okay.
The court should reverse and remand in this Engle progeny case for 3 independent reasons. First, the trial court erred in denying Reynolds' motion for a directed verdict on the fraud and conspiracy claims under the Supreme Court's relatively recent decision in Prentice. Second, the trial court erred in allowing plaintiff to introduce, in plaintiff's own words, extensive evidence, it's in quotes, of, quote, marketing to children in this case where the evidence relates to periods when Ms. Long was not a minor and where there was no claim for punitive damages to even arguably serve as a hook. The evidence was irrelevant and unduly prejudicial. And then third, the trial court erred in giving a modified coercive Allen charge late in the evening in the last day of trial, prompting a verdict a mere 5 minutes later.
Can I do something strange and start with a third issue?
Certainly, Your Honor.
Because I think it's most cut and dried, and I'll give you time to then work on your more complicated issues. The Allen charge, it didn't appear they were in deadlock, which is why Judge Nash basically didn't really give an Allen charge, because they really weren't in deadlock, but they had a question and he felt obligated to answer the question. And do I recall there was an objection to the instruction? I think there was there?
There was, certainly.
I couldn't remember that.
For
Yeah.
an hour.
But the idea that they didn't say we were deadlocked. There's no really way to know whether they were or whether they weren't. So he gave something that was not an Allen charge, but sort of contained some of the key elements of the Allen charge. I guess the only language he left out is that he didn't tell the jurors not to abandon their conscientiously held views. But other than that, it was pretty much had the elements of an Allen charge. Is that a fair statement?
Yes, with a rather large qualification. And there are a couple of things I'd like to say in response to that. One is that you don't need a deadlock for an Allen charge. I think it's Monforto, but we have cited cases in our brief, including the Bryan case from the Supreme Court, where you can give an Allen charge in situations where the jury is having trouble reaching a verdict short of deadlock. I think my more fundamental point is that Bryan, Taylor, Monforto from this court, all of these cases say this is a totality of the circumstances analysis. So it is not about the formal issue of whether we have a deadlock here. It is about whether coercion occurred. And so we just look at the totality of the circumstances.
Well, I disagree with that, because the giving of an Allen charge can be error if you give it without an indication of judge deadlock, correct?
It can be if you give it too soon. The only case that any party has cited in this case for that proposition, the judge gave it, I believe, after they had been deliberating 1 hour, just sua sponte.
So I'm not sure I agree with how you framed that, which is the issue here isn't whether or not there was deadlock, it's whether, I think they both kind of got there together, right?
Certainly the existence or not of a deadlock is relevant to whether coercion occurred on this totality of the circumstances. My point is it's not a strict prerequisite, and we check all the boxes here of coercion in terms of it being late on the last day of trial after they've been deliberating for 11 hours. They send out this note, it's debated for an hour, and then we get this charge. And to Your Honor's point, it omitted some language from the standard Allen charge. The Almeida case says that's the key language, and Allen charge is itself coercive.
See, the thing of it is, the way this thing shook out, Judge Nash seemed to be very careful, very thoughtful. He was trying basically to take what he had, which was not a perfect situation, and do something responsible with it. That's what it looks like to me. Didn't look like this was a cavalier judge who was just kind of winging it. Didn't look coercive to me. It looked like it was thoughtful, careful, strategic, is what it looked like to me.
I am not going to impugn his approach. I will say that the test, the circumstances, look at the external factors, totality of the circumstances. We would submit coercion occurred. But understanding...
If you've omitted something that happened right before this, which was the jury had been deliberating a number of hours, right? But had asked for a calculator. It seems to me that they had moved on to the second, they had checked the box on liability and had moved on to the phase of calculating what the damages were. So I think that's a really important fact if I'm going to consider all the totality of the circumstances at that point in time. So, and, hold on one second. So if we look at the question, the actual question, it's it has an if in it. What happens if we are not able to, determine an amount? So, I think they were kind of wanting to know what the big picture was, what happens if. And I think the instruction that the trial court gave was completely appropriate and responsive to what their question was at the time, given what had led up and what the court knew at the time.
I would suggest that the question does indicate deadlock, because the jury wouldn't ask a hypothetical question late on a Friday night, the last day of trial, and that it was fine. What Judge Long did, okay, he wants to give that instruction, but you got to give the key language from Almeida.
How long had they been into their deliberations after the calculator?
So like an hour, I think roughly. an
I'm
hour.
going to have to ballpark that, Your Honor. I believe it was an hour and 15
But
minutes.
do you liken this to like, sort of a late night mediation where both sides are kind of still far apart in their numbers, but not worlds apart, where they're saying, yeah, we're gonna get there, I'm not sure. I mean, that could have been what they were saying, that, hey, we need a calculator, we're back numbers. What happens if we just can't agree at all? But not necessarily saying we're there yet.
I would suggest that the totality of the circumstances don't support that. Understanding the court's views, I would like to address the first issue about,
I actually have a question, like, is on that first issue.
And you never thought you'd get this much dialogue on the third one.
I'm always happy to answer the court's questions.
Big picture view, 1,000-yard view of Prentice. Because it seems to me that this is kind of what's coloring a lot of this here. So Prentice says, you cannot simply rely on the fact that there was a bunch of advertising, you can't rely on the conspiracy, in other words, that was out there. You cannot rely on silence. It indicates that you must rely on a statement, but in response to the dissent's view in Prentice, which says, well, they're saying it's got to be a specific statement. The majority, I think it's a footnote, says something along the lines of, no, we're not saying it's got to be a specific statement, just a statement, and you can prove that statement in, presumably through inferences, what have you. Help me craft, like, if you had to craft a rule around that, like what caliber or character of statement is necessary in order for there to be sufficient liability on the fraud claim in an annual case. How would you do that based upon what Prentice is telling us? Because I'm struggling a little bit with, okay, it doesn't have to be a specific statement, but it does have to be a statement, and it definitely can't be silence.
So first, I want to note that you have bracketed out two of the things my friend suggested, which is silence or pervasive advertising as a basis of liability. You're right, that is inconsistent with Prentice.
Right.
When you get to the issue of statements, Prentice does say it does not have to be a specific statement, it can be a category. The example they give, and it's necessarily general because it's kind of providing guidance, is a statement, a category of statements saying that filters were heavier for reasons X, Y, or Z without disclosing other aspects. So that is the example the court itself has given us. It has no room to play here because Ms. Long didn't care about filters. There's no indication. The only reference to filters from her testimony is that one brand had, quote, a funny little filter that looked funny, which is not, Prentice requires that the statement be about smoking and health.
Which pertains to your decision as a consumer to consume this product and ultimately lead to whatever health.
Exactly. You can go down the line and, for a opinion that was ostensibly, could have addressed a narrow issue, they gave us a lot of guidance. So they said, you have to have this, you have to show that the smoker received a statement from a tobacco defendant or a co-conspirator. You have to show that it concerned the health effects or addictiveness of smoking. You have to show that the smoker believed the statement. They talk about reliance has to be reasonable. You have to show that they acted on it to their detriment. And you have to show that it caused their injury. That's kind of baked into the detriment point. But that's a lot of guidance. So we can look at the actual statements that Ms. Long identified because she testified in this case via deposition. She spent the biggest category are things like there were dancing cigarette packs on the hit parade.
There was the jingle that
Exactly.
she didn't remember, right?
Exactly. And so
Her deposition candidate said, I don't remember seeing statements.
exactly. And so you look at that, and we know that that doesn't suffice because of the reasons that we just mentioned about Prentice. It doesn't concern the health effects or addictiveness of smoking. And so then we can look at his first principles. Prentice emphasized that reliance must be reasonable. It's not reasonable to form a belief about the health effects or addictiveness of smoking based on a jingle. And you can't have actionable liability for puffing. So what's that leave? That leaves this one telephone call to R.J. Reynolds, where in the middle of the 1980s, middle of her smoking history, so she smoked for about 50 years, this is give or take 25, 30 years in, she calls Reynolds, says, do Winston ultralight cigarettes have less tar than regular Winstons? She specifically, well, she cannot recall if lights even came up at all in the conversation. And she's told yes. And there's three separate reasons that that phone call cannot be a hook for liability. One is just causation. Prentice repeatedly says, look, reliance and causation, they kind of go hand in glove. They're not the same thing, but they're doing some of the same overlapping work. And so here, we know that Ms. Long testified that she smoked ultralights for, quote, not long. She couldn't commit to a week or a month, even a carton. And so that sort of de minimis smoking, especially in the middle of a smoking history, that cannot support liability. I don't think proof is needed, but if it were needed, plaintiff's own evidence refutes his point, because Dr. Cummings says, look, it takes 10 pack years to elevate disease risk. And so certainly a month, a week doesn't suffice. Then you have reliance. Prentice says that reliance must be reasonable. It's drawing on the traditional common law rule. And that it's not reasonable if the smoker knew the truth. Well, here, Ms. Long testified that she knew what was allegedly concealed, which is that you smoke more if you smoke something like ultralights. You either smoke deeper or more often. She acknowledged in her deposition, yeah, I gave them up essentially right away because I was just puffing too hard and smoking too much. And so the reliance would be reasonable. Finally, there's the fact that the statement is narrow, true, factually, and compelled by the federal government. And so the statement is just that ultralights have less tar than regular Winstons. Dr. Cummings acknowledged, using the then federally mandated testing mechanism, that was true. They had significantly less tar. And he acknowledged that the federal government made the tobacco companies use that mechanism and told them they couldn't even report higher levels of nicotine if they wanted to. There's a quote where Dr. Cummings is talking about Lorillard, and he says, look, they asked, can we tobacco companies report more tar for these cigarettes? And the FTC wrote back and said, absolutely not. You've got to use the federal method. And so Reynolds certainly can't be held liable for a factually true statement that the federal government compelled it to make. Very briefly, if the court has no questions on the remainder of Prentice, the plaintiff introduced a lot of youth marketing evidence from periods when Ms. Long was not a minor.
Well, and I got a question about that.
Absolutely.
So your argument on that issue is kind of both irrelevant and highly prejudicial, given the fact that there's no punitive damages claim. And I guess I see an Engel case when it comes to evidence on this issue. I feel like Engel case kind of sets the bar a little bit different on whether or not it's unfairly prejudicial, given the phase 1 findings. And I'm thinking of the finding number 5, that's already going to get there in front of the jury. Once you're telling a jury that the defendant concealed and omitted information about dangers of smoking with the intent that, quote, the public would rely to their detriment, is it really unfairly prejudicial to include evidence of advertising to minors who are definitely part of the public?
Respectfully, yes. The findings are exactly why it's unnecessarily prejudicial. They've already got the findings for company conduct. They don't need to prove anything at all about company conduct. And certainly, this is the most, and we shouldn't lose sight of it, it is the most inflammatory type of accusation. We have lost it before in the Townsend and Allen cases when punitive damages were in play. We don't think that was rightly decided, but we accept that those precedents are out there. But when punitive damages aren't even there as a hook, Engel itself, Douglas to follow, says all of these issues are now about the individual smoker. And the fact is that this...
So as you see it, we should have a didactic cutoff point right at the moment you turn 18. Evidence of anything of youth marketing is just beyond the pale. You can't even consider it because adults don't ever watch kids, 18-year-olds don't watch programs or marketing that's directed to kids. Help me out.
I would come close to
And
the.
you're at 15 minutes.
Thank you
Just
very
so
much.
know, It's your time. Use it.
Understood. I certainly want to answer the question, which is very close to a cutoff. Now, if a specific,
I appreciate the candor.
but if a specific smoker came in and said, look, I cared a lot about these, we might be having other debates in the context of Prentice, but it wouldn't relate to addiction or comparative fault. And here we don't even have that connection. There's no suggestion that Ms. Long saw any of this. A 1990 letter to, school children when she's 60 years old does nothing but inflame the jury. I'm happy to answer any of the questions. Otherwise, I will reserve the remainder of my time.
Okay. You'll have 4 minutes when you come back.
Thank you.
Yes, sir.
Good morning. May it please the court, George Baca on behalf of the estate of Carolyn Long. We're here today asking the court to affirm a judgment entered pursuant to a unanimous jury verdict, which found in favor of the estate on negligence, strict liability, and both the intentional torts in this Engle progeny case. I'm not going to go through a very detailed discussion of the facts because I did that in our brief. And probably was the longest statement of facts that I've ever written in a brief for that matter.
Well, it might be helpful that, help us understand what statements she detrimentally relied on.
So it's clear throughout this case that Mrs. Long heard messages from the tobacco companies. She even called one in response to one of the messages that she heard. What Mrs. Long testified to and what Mr. Long testified to was her belief that smoking these cigarettes was less harmful or more healthy for her. Dr. Cummings testified that that message came from and emanated from one source and one source only, which was the tobacco companies. So Dr. Cummings, through going through the corporate records, explained to the jury about how there was these brand extensions and how the tobacco companies knew that their brands were aging out and that they sought to keep people continue to smoke their brands who were concerned about their health. And so just like Mrs. Long, there were other people who switched from Winston to Winston Lights and then Winston Light 100s. So Prentice says you can prove your case by inference and circumstantial evidence. So Mrs. Long says she believes that they were more healthful for her. Mr. Long says the same thing.
Can I ask you a question? Because I'm holding the Prentice decision. And
Yes.
I've asterisked language that I keep looking at, reading and pondering, say, what do they mean by this? And here's where I keep focusing on. The opinion basically says, we agree that reliance on a statement does not require proof of reliance on a specific statement, and our holding must be taken to include this understanding. What do they mean by that?
I think if you go back, and I don't know exactly what the court means, I can speculate what the court means. If you go back in time, okay, so the court obviously had to review the entire Engle record. If you go back in time, there are messaging that is going out by the tobacco companies. It's not just this brand has this filter that's going to take out this carcinogen. It's a bigger message, and it's not focused solely on the facts. This is better for you. This filter's better for you. Knowing full well that the filters were a gimmick, because that's what they're.
But counsel, it seems we can debate and try to, figure out the existential line that the Prentice was drawing between a statement versus a specific statement. But I think it would be fair to say that in saying that you can rely upon, inferences, what have you, related to statements, the court did not mean to undo the centrality of its holding, which is that you can't just rely in general on conspiracy. And the tenor that I'm getting from the briefing and what I'm hearing today is, look at all this bad stuff they did. They did it on purpose. She relied on that. Which is basically just a backward way of saying.
She relied upon the messaging, smoking these cigarettes would not be as deleterious to her health.
But isn't that why I got reversed and my Dunnigan 3 opinion got reversed by Prentice? Isn't that what I said there?
Well, I think that that's there.
I don't even know what I said.
I think if we go to the decision that came out subsequent to Prentice, it came out of the same court that gave us Whitmire and Prentice, which is the Cudahy case. The case that the defense doesn't even cite to in the reply brief, even though we brought it up. So if you look at the Cudahy case, here's what the court says. First and foremost, the court says that an unsuccessful angled defendant who challenges the sufficiency of detrimental reliance evidence in the trial court can prevail only if there's no proper view of the evidence or inference from the evidence that supports the verdict. That's the first thing the court says. The second thing the court says, they talk about Whitmire and the fact that the only thing in Whitmire was the decedent had heard advertising. And they say, we thus concluded that before tobacco defendants can be held liable for concealing or conspiring to conceal the health dangers of tobacco products, some direct or circumstantial evidence must connect decedent smoking to the false information that was disseminated by the tobacco companies. Then they go on to say, when viewed in a light most favorable to Appleby, which is the estate of Mr. Cudahy, the non-moving party, the detrimental reliance evidence connects statements made by the co-conspirator tobacco company with the decedent smoker's decision to switch to a supposedly low-tar, less addictive brand of cigarette for health reasons. Specifically, according to family witnesses, the decedent switched to low-tar merits after developing a cough and discovering that he believed to be a more healthful, less addictive cigarette. That's exactly what we have here. Mrs. Long had breast cancer back in the 70s. She was concerned about her health. She switched to the Winston Lights because she was concerned about her health. She testified to that in her deposition. Her husband testified to it. And it's exactly what the tobacco companies planned for her to do. Mike Cummings said she was one of their greatest successes because her behavior followed exactly what they engineered it to be.
If we were to agree with your position on issue 1 and affirm, wouldn't we have to certify conflict with the first DCA's Whitmire case?
I don't believe so. I think if you look at Cudahy goes and distinguishes Whitmire, and it does so for the very same reasons I'm asking the court to do it. Okay? First, that he made his decision based upon that. Second, the decedent's daughter expressly identified certain advertisements, but then we go on and say, other evidence showed that the decedent was on their appellant's mailing list and received information. Well, in our case, there's no evidence that Mrs. Long was on a mailing list, but she clearly received information because she got on the phone and called them and said, is this really true?
And it didn't end up mattering because she didn't end up smoking those cigarettes. She couldn't recall how long she smoked those cigarettes.
But the point
She ended
that
up-
making Judge Lucas is that she heard their messages. The jury could have inferred that she heard their messages based upon the fact of that incident where she heard the message and she made a
I don't
phone
think
call.
there's any dispute that she heard advertising, that she heard messages, but she couldn't recall any other than that one call that, you know, again, arguably, according to your friend on the table here, was a factually correct and federally mandated statement. Doesn't seem to matter because she didn't end up sticking with the wet cigarettes anyway. Other than that, once you put that aside, all you've got is her saying, yeah, I remember a jingle and I remember it being really cool to, you know, everybody in my college was smoking and, you know, it's just what people did.
But she also said she thought she was switching to a safer cigarette, and that's what Cudahy is all about. That's what the 11th Circuit's decision in Kieran is all about.
But Prentice says reliance on a statement can include a category of statements addressing a particular topic.
Correct.
So she doesn't necessarily need to say, I remember this particular statement. It sounds like that she's able to say, this was the gist of their advertising during this time, sending this message, and I remember.
Yes, Your Honor, and that's the point I was trying to make, is that they were giving out messaging. It wasn't just right, if you go, I think there was testimony concerning True Cigarettes with their weird filter, Parliament, they all had different gimmicks in their filters, right? She's not required to prove, and the estate is not required to prove that she relied upon any one filter. They could have, but that's not what the case law requires. The case law requires that she be the recipient of and rely upon the messaging that was being given by the tobacco companies, and she relied upon it to her detriment. She started smoking the light cigarettes after she had breast cancer at a point in time she was trying to quit. She even had a staple in her ear. And our court remembers that testimony, okay, because she believed that that would help her quit. And what wound up happening was she wound up being further addicted to the nicotine in their cigarettes and smoking for at least another additional 20 years.
Maybe can you parse for me that after this statement, the telephone call, do we have like a break where there were these additional statements that caused her to continue, like to abandon those and then continue smoking?
The testimony is she continued smoking until 2002. There's no,
I guess I'm trying to, there's this messaging that she heard before she switched.
Correct.
She switched because she wanted to, because she had cancer, and then she switches to a lighter cigarette. Is there a message that, okay, well, I'm gonna go off the lighter cigarettes and continue with these other cigarettes? Is there a message? Not that I know that it's relevant, but for me, I'm trying to figure out, well, she stopped the first cigarettes, went to something lighter because she thought it was healthier, but then she goes back to the cigarettes.
No, she didn't go back to the Winstons. She never went back to Winston. So the progression is, she starts with a Salem back in the 1950s. She then progresses to Winston and Marlboro. She then progresses to Winston Lights, then Winston Ultralights. So I grew up in this time, and I specifically remember all these things. Winston Ultralights come out.
Then she goes back to the lights, and that's probably.
Correct. She calls up in response to the ultralights. She says she stopped smoking. My recollection of the testimony was, she said you had to suck on them until you turn blue. And so she wasn't getting all of the fulfillment that the smoke otherwise gave her.
Okay, so she went from ultralights to the lights.
Correct. She went from lights to ultralights to lights. And she was only on the ultralights for about a week. So there's no argument here that the one misrepresentation was the ultralights. The relevance of that evidence is she was receiving the information that was being put forth by the tobacco companies. That's clearly one of the reasonable inferences that you can draw from this evidence. She heard it, she relied upon it, she changed her smoking behavior from regular Winstons to lights, and she did it to her detriment. And that's all that Prentice requires. Prentice allows us to use circumstantial evidence to prove our case. And those are all reasonable inferences. And we only need one. We only need one inference in order to draw that conclusion. So if the court doesn't have any further questions on that part of the case, that issue, I'd like to move on to the youth marketing issue. And this is, to me, is one of the crazier issues that they've raised, because Judge Nash, this was his first tobacco trial. And in Hillsborough County, there is a whole series of orders, county-wide orders, pertaining to tobacco trials. And the 13th Judicial Circuit sat on bonk and came up with 40-something different orders addressing these broad categories of objections that plaintiffs and defendants had. And one of those was the all-county order regarding youth marketing. And it's very clear what that order says. It says, Defendant's motion in limine denied as it pertains to all of youth marketing. But you're not precluded from making case-by-case, fact-specific objections to any other evidence. It's what is invited to happen under the order. So Judge Nash, right, we're going back to, did he abuse his discretion with respect to the admissibility of this evidence? Judge Nash, faced with a countywide order en banc of his circuit.
Just out of curiosity, like what, I hadn't heard of that before, an en banc circuit court order applying to regional cases. There's some kind of administrative order that preceded that, or, I don't mean to get you off the rails, I just.
No, 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 I actually have a copy of all the orders. If Your Honor would like to see them, I can approach the court with them. But what happened is, like in Jacksonville, in Ball County, there were all county orders, and because of the difficulty in handling however many different divisions there are in every different circuit, some of the circuits decided to just have countywide orders so that it could speed up the process. And Hillsborough is one of those. And so Judge Nash followed that order, and the defense raised no, not one objection to any piece of evidence thereafter. So we would say, one, it wasn't an abuse of discretion for the judge to follow the order that he had been administratively told he needed to follow. Two, the defense was given specific instruction as to what they were supposed to do if they wanted to object to a piece of evidence, just like you would in any other case. If you have an objection, you raise it contemporaneously, and you give the opportunity to the trial judge to make a call. That didn't happen. The third reason I want to talk about this for a second, Your Honor, you brought up a really good point. I brought this up in the post-trial hearing. They want to have this black line. And as soon as you turn, quote, 18, you're an adult. Factually, that argument is wrong. Regardless of all the other policy, just factually, it's wrong. The legal age of majority in Mississippi now and then is 21. So they're stuck to the parameters of the objection that they raised. The objection was she was beyond 18, and that was the age of majority. That's wrong. So there's no other.
Well, what's confusing to me is that means if you're over a certain age, you're not listening to that advertising.
Oh, I don't agree with it. I certainly don't agree with it, but I mean, factually, if you want to accept their premise, it's wrong. It's just flat out wrong. So that was the basis upon which they made their objection. It was you can't have any evidence of advertising or youth marketing that was created or came in after she was 18. Because that was the age of majority. That's their motion in limine. It's wrong. Last, I guess, but not least, I was going to just cite the court to Judge Nash's thoughtful discussion of this jury question. And the court has done a good job looking at the totality of the circumstances of that as well. I would point out that at the time that the jury requested the calculator, they also requested a pizza. So they were planning on being there a while before they finished their calculations with the calculator that they had received as a result of their request.
Well, an old trial judge, we sort of knew after juries ate, they almost always had a decision.
So if the court has no further questions for me, I'm happy to answer whatever questions you have. We would ask the court to affirm this judgment and to allow us to put this case behind us and go to the next one. Thank you.
You have 4 minutes, sir.
Thank you, Your Honor. Very, very briefly. First, I do want to, because it came up again, give the court the cites for the FTC testimony. That's R 15756 to 58, 16064 to 65, and 16063 to 73, including the mandatory nature of it. Second, I heard my friend not identify a statement, which goes back to Prentice wasn't written to be self-defeating. And I did hear a lot of talk about the Cudahy case. There was an ellipses in the description, and I think this is a key sentence. Additionally, comma, decedent's daughter expressly identified tobacco advertisements as the source of the information, prompting decedent to switch to Merritt's because he used words, quote, almost matching verbatim the language of the advertisements. I think this proof that Prentice works. It doesn't make an insurmountable hurdle, but it does mean what it says.
Let me ask you this, Mr. Baccarat brought this up, and I will confess, I don't have the latest Long's smoking history probably as well as you all have it in your heads. I remember, she started in high school, continued in college, in Salem, so it was Winston's, and it was Winston Lights, and then Ultralights, and then what I heard was that she remained a Winston Light smoker for the remainder of her days. Is that correct?
I believe, and I'm just pulling out to verify.
And I asked that for a specific reason. If that's the case, wouldn't that arguably, that telephone call take on a greater level of importance, potentially, at least in terms of identifying her reliance on what the tobacco companies are saying?
So it doesn't speak to the causation point, and I think the broader point is it doesn't identify.
If those two, we know that those two things, reliance and causation, are supposed to do two different analytical things.
Yes.
We've been reminded of that by the Florida Supreme Court. So I don't think we can't conflate them. They travel together, but we can't conflate them.
So I agree, but I would just say this, returning to your old brand does not signify any reliance on statements, especially when, and this is important, Ms. Long testified that she doesn't know where she got the information about lights and tar, and she kind of said maybe it was the radio, maybe it was the TV, I don't know. She said that in that call, the call that you're referencing, she didn't remember if lights were even mentioned. So she's clearly differentiating the two brands. So we just have no statement that supports the idea of reliance on statements about lights. I'd add that the same point about it being true and FTC compelled applies just as well to lights as it does to ultralights, because it's still the tar numbers. And finally, this was a question raised about whether the court could go my friend's way without certifying conflict with Whitmire. You can't. And one of the things Whitmire said is that the mere fact of the word lights on a cigarette pack is not a basis for liability, because otherwise you're taking the individualized showing that Prentice is clearly requiring, and you're just watering it down to nothing. And so you're back to basically using that sort of.
Well, that's what's confusing about Prentice, because while it says that plaintiff must prove reliance on a statement, it then says reliance on a statement can include a category of statements addressing a particular topic. It's less than clear.
So I think that you can make perfect sense of that. So filters or lights themselves are not statements, but if there were statements about filters are healthier, that might be your qualifying statement. And so that might be your category, but you do have to make the case. It's not just the whole universe of statements, this person's smoking.
Well, if she's asking about there being less tar, I mean, she's asking our light brand or Ultralight brand cigarettes healthier.
She did ask if ultralights were. That shows she cares. It shows no reliance upon the statement, certainly not in connection with lights, which she acknowledged were not discussed on that phone call. And then finally, my friend mentioned.
And you're out of time, so just wrap it up. That's okay.
Understood. We would urge.
Make your point, though.
The last point I was going to raise was the idea that there was no preservation raised with respect to youth marketing is wrong, both because the motion in limine was denied categorically, and Reynolds repeatedly said no further objections, bracketing the objections it had already made, and the trial court acknowledged that, saying it's admitted, I'm standing by my earlier ruling. So we'd urge the court to reverse. Thank you.
Thank you. Your briefs were great. Your arguments were very helpful. These cases always involve a lot of hair splitting about what the law does and doesn't say. Have a good day.
Thank you.
Let me see. Our next case is McNulty Lofts versus McNulty Garage.